Charged with killing his stepfather, but allowed out of jail as long as he promises to go to school. Man, this is rare to say the least, but that's exactly what happened late last month in the Cecil County case of 15-year-old Willie Woodbury and his alleged murder of Vincent Robertson last year in Port Deposit. So tonight, we go in depth on this and explain just how this judge in this case let this happen.
Jamie, after 6 months in jail, the judge set a modest bail for Willie Woodbury last month and told the 15-year-old he must go to school while he awaits trial on murder, conspiracy, and assault. An accused murderer out on bond and back in class. It was last February. Police found 47-year-old Vincent Robertson lying face down in his own blood, dead from a pair of gunshot wounds. It would be a few months before his wife's 3 sons were arrested for the murder of their stepfather. We caught up with their mother, Tina Robertson, last July after her 3 sons were arrested.
I don't understand why these police are doing us like this, but I just want my kids out of jail because I know they didn't do it.
Well, as of last month, 2 of her boys are now out of jail, while her oldest, Elijah Juan Monk, remains in jail awaiting trial on first-degree murder. Tina Robertson's 2 other boys have been released, including now 15-year-old Willie Woodbury, free on pretrial release while carrying a first-degree murder charge.
It is generally rare, however, the circumstances of this particular case, in my opinion, almost mandated the judge to make this decision.
And eventually, Judge Brenda Sexton did. Because Woodbury's attorney, Edward Riccitelli, successfully argued Maryland State Police tried to question the 14-year-old even after he asked for an attorney to be present during his questioning last year. It's a statement that should freeze any interrogation, but didn't in this case. It's a moment you can hear in audio obtained by In Focus of 2 detectives speaking outside Woodbury's questioning, one even mimicking Woodbury wanting a lawyer present.
He's already said that, he said, what are they doing? I said, they're going to be questioned. Yeah, I ain't going to answer no question. Not my lawyer not here. I said, that's not a good start.
Regardless of that moment, Woodbury did go on to make statements on February 17, 2014. Statements the judge ruled last month should now be inadmissible. According to court transcripts, during the proceeding, the judge explained her ruling, saying, quote, I find that if an individual states that he wants to have an attorney and it's an unequivocal statement to that effect, interrogation must in fact cease. I find that it did not cease. I find that the statements made by the defendant, Woodbury, on February 17, 2014, should, in fact, be suppressed.
Right from the beginning, my client, who was a 14-year-old at the time, had said, you know, he wanted to speak with a lawyer, and the state police did not provide him with a lawyer, nor did they stop trying to get him to make a statement.
With evidence suppressed, Riccitelli then moved to ask the judge to outright release Woodbury, who had been in jail for 6 months already. At 15, he argued, his client, quote, needs to go back to school or else he's going to miss all of that. Judge Sexton granted that request too, setting a very modest bail for the accused murderer at $25,000 under the condition Woodbury goes back to Perryville High School every day while he awaits trial. While word spread quick of this rare pretrial release, Cecil County schools acted according to an existing district policy.
We must transition students back, whether they're coming back from incarceration, they've been released. We then put together a plan to transition them back into the educational environment.
Kelly Keaton with the school district explained that while she couldn't speak specifically to Woodbury's case, cases like his involve a reintroduction plan that first starts here at the district's alternative school.
It's very individualized. It depends on the student, the circumstances, a number of variables that are taken into consideration.
It's assumed Woodbury is undergoing that kind of plan at the Providence School before attending Perryville High School. The teen still charged with first-degree murder, conspiracy, and assault. A case the state could not defend warrants Woodbury continuing to be held without bail. That could change. Now, just last week, the state appealed the judge's ruling in this case about suppressing evidence. According to court documents, the state will argue the evidence excluded by the judge is indeed substantial. That appeal process could take 6 months. All the while, Woodbury will remain out on bail. While Woodbury and his younger brother are back home, their older brother, Elijah Juan Monk, remains charged and in jail for the murder of Vincent Robertson. His trial is scheduled for May of this year. We did reach out to the Cecil County State's Attorney's Office and the Maryland State Police for comment on this story, and both declined to speak about this case.